Hello, this is attorney Andrew Kinney from Hoglund Law Offices. Our offices are headquartered in Roseville, Minnesota, although I do hearings across the country, usually about 500 per year at the current rate in 2024. In this video, I've had other videos, but in this video I'm going to talk about what an attorney is supposed to do for you before and in your hearing. That's a crucial decision. You do not need to get help for your Social Security claim or in your hearing. That's not required. And also non-attorneys can help you as well. But in the end, whether you want help for your Social Security claim or not, it's an important question to ask. And I mentioned in another video, and I'll repeat it here, if you're not sure, if you want to hire someone, it would be important at least to get an application in. You can do that online or at a local Social Security office, but it's important to get your case moving along because Social Security claims can be slow. From the application to a hearing, it's at least a year. There's an application, reconsideration level, and then a hearing level. After that, there's an appeal level. But that whole process, even though I could say it quickly, takes a while. So here's what a law firm and an attorney can do for you before your hearing. We would help you apply for benefits, make sure the application is complete, make sure the information that Social Security needs for their state agencies making the first two decisions is complete. In terms of where you're treating, we would also help you, and we also help you with forms. Social Security at the application and reconsideration levels ask you for more information about your past work, for example, or about your functioning at home. It's important to get those forms completed and back on time. Some people have questions about them. Our law firm will help answer their questions. We don't want to fill these forms out for you because this is very personal how you function each day. But what we do want to do, and I'll relay it here, is keep it direct, straightforward, and answer the question about how you're functioning now. So for example, in an activities of daily living form, make sure to comment on how you're functioning now or be clear about things you used to do that you can't do now, as opposed to saying you like hunting. Is that now? Is that what you used to do? Because Social Security is reviewing these forms and deciding how you're limited, and the assumption is this is what you're doing now, unless you're clear. Any event, another thing a law firm and attorneys can do is help you appeal on time. Any law firm would get a copy of any letters you get from Social Security, and if it's a denial letter at the application or reconsideration levels, for example, there is a time frame to appeal. Those letters will be clear that you have about 2 months to appeal from the date of that letter. A law firm would set up a time, our law firm, for instance, would set up a time to help you appeal that online. So in other words, making sure appeals that you need to make, because you do need to get to a hearing, that's very important. Appeals you need to make are completed properly and in on time. Before hearings, law firms can also help you and should and are supposed to help you gather all updated medical evidence. So as you get toward a hearing when it's scheduled, our law firm and other places will call and verify they have access to and know about everywhere you've treated. And that may include non-medical sources like vocational rehabilitation and maybe PCA records, which aren't treatment records but can be helpful. All that information at the hearing level, your law firm would get for Social Security and submit it on your behalf. And then finally, as you get close to the hearing, and this is what I do every day, it's important that your attorney that will be doing the hearing with you listen to what your medical issues are and understand how your medical issues affect you. We can read records all we want, and I do that every day, but ultimately you know how the different medical problems you have limit you. And there are practical things like how they limit you at home, for instance, doing dishes or trying to vacuum or trying to do laundry. If there are physical problems, they affect you in unique ways. The only way to know about it is to talk to your attorney before the hearing about those kinds of things, because those things come up at hearings, and it's logical that they do. If you have depression or anxiety or problems along that line, your attorney would want to ask how often you might get overwhelmed by anxiety. How long do the panic attacks, if you have them, last? And are there any triggers? We can read medical records, but your providers are not at home with you. How often these things happen will come up at the hearing. Your attorney for your hearing needs to understand this before your hearing. Just heads up. And then finally, your attorney that will help you with your Social Security hearing itself will explain what to expect at the hearing. And a summary of that is that it'll either be by phone or be video or in person. However, whatever the format is for the hearing, the start of the hearing, the judge verifies who you are. The judge will have witnesses, a job expert, and you, maybe others, but at least you two, verify that you're telling the truth by raising your right hand. And then the judge will usually ask about your past work that you've done. And then the judge will ask you direct questions about your functioning at home and why you stopped working and what kind of treatment you're getting. Do medications help? Things like that. Your attorney will then follow up and clarify questions if necessary, and your attorney will also follow up on things that might have been missed with his or her questions. That's important in the hearing. The next thing that the attorney will do is when you shift to a vocational expert, for anyone 18 or older, there is a job expert in every hearing. The judge will pose hypothetical questions to the job expert. The job expert will answer based on certain limitations. Do jobs exist? That's in essence what's going on. But the attorney in the hearing will cross-examine that job expert about the job numbers or the jobs that came up, or the limitations as to how the vocational expert understood or didn't understand the hypothetical questions. Or your attorney will add questions like absences or time off tasks, things like that. That's a basic summary of what your attorney will go or should go through with you before your hearing. And your attorney in the hearing will have an opening statement, and usually the judges want that, and a closing argument at the end of the hearing. And then as I laid this out, your attorney needs to be aware of how your medical problems have worsened over time from when you stopped working to now, because there is a trend line or a medical narrative that I call, where different problems might get worse over time. Usually they do. Your attorney will make sure to clarify when new problems might have arose versus last year when you had other reasons you couldn't work. And finally, the thing you'll see an attorney do is lay out where in your medical record are the things that the judge needs to see, like an MRI or an X-ray or a diagnostic assessment for emotional issues. Some records are more important than others. You'll also hear the attorney mention the law. There are some laws that apply, that may apply in your case. It's called a definition of disability or listings. The attorney will also point out to the judge perhaps how age 50 or age 55 may help you, the legal standard changing, and point out where in the record would prove that. But in any event, when the hearing's done, they generally last about an hour. Your attorney should also contact you and talk with you about what's next. What should I get if I'm approved? What will happen if we're denied? Should we appeal? Should we start a new claim instead? And at times, your attorney may write a follow-up argument based on what happened at the hearing in a written legal brief. That's something that might be necessary depending on what happens at the hearing. All in all here, this is what your attorney should do. And one of the challenges is if you're hiring a law firm, how do you know your attorneys will do this? You can ask when you call a firm, ask if they're a law firm, ask if the attorneys that are in this law firm will be the ones that are in my hearing as opposed to outsourcing or a referral service. Very important. And make sure that you ask other people if they've been through this process before. I had a recent referral from someone that was in physical therapy for me. I appreciated that. That was something that I had helped someone else in their family. Ultimately here, whatever help you need, make sure to apply, make a decision. If you would like help applying or at least help at the hearing level, that's okay. And hopefully things go well for you. And by the way, if you do get better while your case is pending, it is good to talk with the law firm or lawyer that's helping you at that juncture. If you can make over what's called substantial gainful activity while your case is pending, that happened today, that means that you're making roughly over $1,500 a month gross in 2024, it goes up each year, that may affect your case. So make sure to find out ahead of time what the issues are. It's okay, and it's good to know things ahead of time. In any event, hopefully this information was helpful. Hopefully you find a good attorney or a good law firm or a good non-attorney firm. I just want to make sure anyone that wants help gets good help. And if there's some problem, you have a right to change who's helping you. Just heads up. In any event, this is Attorney Andrew Kinney from Hoglund Law Offices. Hopefully this is helpful. And if you need any particular kind of advice, make sure to not comment on the comments below, but feel free to call us or another law firm with details here, because this is general advice, okay? Take care.